if there's an easement that cuts right through the middle of it, that might blow up your plans. So if someone's claiming that for the last 22 years they've been using that as a footpath to get to their deer stand, that's going to cause a problem.
They say, as far as like the mass texting, like if you are able to have a one-on-one conversation with them, it doesn't deem mass marketing. If you send 100,000 texts in a day, it's like there's no way you can respond to every response.
Local people didn't want the Costco, the not in my backyard. When the town denied the rezoning, they didn't do so in accordance with their own ordinance. So now Costco is in Mooresville.
All right, everybody, welcome back to the Real Estate Investing Podcast. Super excited to have, this is the first lawyer we've ever had on, Tiffany Webber. She is a real estate attorney. She does a lot of stuff in North Carolina. Tiffany, welcome to the show.
Thank you so much. I can't believe I'm the first attorney that you've had on the show. What an honor.
That I can remember, to be honest. I could be wrong. We've done a lot of these, but it's the first time we've ever been like, all right, we have so many questions from our community for attorneys. Just talk about your background a little bit, Tiffany. How long have you been doing this? What does that look like?
Yeah. So I've been practicing just shy of 10 years. I started out in litigation. Most of my litigation cases, oddly enough, were about real estate. So it seems like from the very beginning, all I really wanted to think about and do was real estate. But after a couple of years in litigation, I switched over to the real estate closing side of things and handling all sorts of things with development, cases about zoning. And so I've spent the last 8-ish years or so just focused solely on real estate, and it's been amazing.
So are you doing mostly just closings, or what does that kind of encompass? It's a lot of different things.
Yeah. Well, I'd say it's mostly anything to do with real estate other than going to court anymore.
Yeah.
So I've gotten out of having to go to court, which is great. So development, of course, closings, both residential and commercial, helping people figure out how to solve pesky problems that are keeping them from getting, a zoning permit or a building permit. It kind of runs the gamut there.
Yeah, that's awesome. And appreciate that insight for sure. And excited to get into it. With real estate, and I'm sure with the law around real estate and so many wholesalers out there, so many people that are doing so many different things, and some people do it in a very ethical way, some people are doing it the exact opposite. What are you seeing right now in North Carolina nationwide of just laws changing? I know double closing laws, wholesaling laws have changed recently in South Carolina. What are you seeing on a state level in North Carolina, and then a nationwide level, and where do you think that's going?
Yeah, I don't know the details, but I believe there's some legislation that's been introduced in North Carolina as well that may affect how that whole process is carried out and what wholesalers may be allowed to do. But from an attorney's perspective, we really only have one way to do it correctly. And actually, that's wrong. There's two ways to do it correctly in North Carolina. One is, you've got your A, B, and C. B buys from A and then C buys from B. So really, truly two separate closings, or an assignment, which a lot of people are just referring to as novations these days to try to get around unauthorized practice of being a real estate agent, so it doesn't seem like a commission. But those are really the two ways that we see them go down. We don't do a ton of them in my area. I'm just north of Charlotte. I'd say there's much more activity like that in Charlotte, but in the Lake Norman area in North Carolina, not quite as much activity, but we do see our fair share of it come through as well.
So are you seeing typical things of people like this, that are doing things wrong or doing stuff? What are you seeing? No, I can't handle that. That's just not how we are allowed doing things like this.
Right. Yeah. So trying to use the end consumer's money to buy from the original seller. So just skipping right over the B entirely. We get people to ask us to do that, and we just say the law doesn't recognize our ability to do that, and we are not stepping in that mess. So if you find someone to close it, it will not be us. Some people don't like that. That we certainly don't want anyone to feel as if we're accusing them of trying to skirt the law. A lot of times it's just lack of education, or maybe they see something that's allowed in some other state and they try to do it here. So we have to explain to them, it doesn't quite work like that here. They don't always love our answer, but we won't do any of those transactions where you're trying to use the ultimate buyer's money to buy from the original seller.
That makes a lot of sense. And I'm not sure. I don't think many states, I don't know any states that we've never done that, where you can always get transactional funding and it costs 1% or something like that, whatever it is. And there's so many opportunities for that the deal actually makes sense. But So we're buying land under market value, typically reselling whatever. A lot of times we don't do ABC. A lot of times we just do A and then we post it on the market. And like I think that,
Mhm.
but when people are doing ABC, double closing is what we call it. Is that the term you guys use, or do you guys use double closing as a term for that ABC?
We so we have in residential closings, there's a whole other thing that's a double closing. So internally, we don't call it that, but we understand when people call us about it, we know what they're talking about. So we just call it an assignment contract, or, essentially just scheduling two different closings for that
Got it.
purchase.
So when someone's wants to do this, they get a property under contract. Like, how do they make sure that contract's solid where they can list that property?
Mhm.
What does that look like from an investor standpoint? Like, I want to do this. I want to flip this property. I don't want to buy it outright before I flip it. Like, how do they lock in with the seller? What do those contracts look like? What's a part of those contracts to make those solid contracts where you
Mhm.
can't list it? I don't know if you can list on the MLS or not in North Carolina. What does that look like?
Yeah, so one of the key ingredients to the primary contract before you ever list it for sale is making sure you get the right to do that. It's all about disclosure in our state. It's what does the seller know? What does the buyer know? So there really can't be anything hidden. And that usually will find people that'll try to be extremely simple with their contract, and that's fine, but it doesn't always address every right that you need. And so they'll ignore something really big, like being allowed to market a property that you don't own. Our North Carolina standard offer to purchase, let's say you're the one that's going to buy that property and you're going to list it for sale and you want to list it before you've closed on it. Our standard offer to purchase in North Carolina does have an option for you to say whether or not you own the property yet. So a buyer might know, oh, they don't yet own it, but they're going to come into ownership at some point before I purchase it. So it's another way to disclose. But getting the permission up front from the seller, and being clear that, yeah, I'm going to end up selling this to someone else, especially if it's going to be all in one transaction where there's some sort of assignment fee or novation fee on the contract.
And how does an investor stay away from being backdoored or something like that, where they can have a lock solid contract? Because they're so
Mhm.
you list the property, and then the buyer's like, okay, I see you don't own this. You're not on the deed right now. I'm going to call the person who's on the deed. Like, how does, as an
Mhm.
investor, how do you avoid that?
Well, you can't always, unfortunately, because bad actors or people that want to skirt around, agreements are always going to try to find a way to do that. So you may not be able to stop it before it happens, but if your contract has appropriate remedies, then you may be able to get compensated for it or try to enforce a contract. So in North Carolina, sellers can't really back out. If you're using our standard form, at least, you don't have a way for a seller to just say, no, I'm not selling to you anymore. So a buyer has the right for specific performance. They've got access to all sorts of damages in the case of a seller breach, but specific performance being the really big one that you can make a seller perform on the terms that were agreed to. So that would be one thing that if you're an investor, even if you're not using the standard offer to purchase, you're going to really want the remedy of specific performance to be included in that contract so that you can then make a seller perform. Now, on the other side of things, if you've got a buyer that sees, oh, there's really someone else I can go try, you can't make a buyer stay in a contract. So in North Carolina, a buyer can walk away for any reason at any time. Now, they may lose their deposits,
Hmm.
and that's just got to be something that a buyer's got to accept if they're going to walk away. But you can't make a buyer buy, but you can make a seller sell.
Yep.
So there's at least one part of the transaction that you can protect if you include that remedy of specific performance. Now, I don't want to give any illusions that that's a quick process because you do
Hmm.
have to get the court involved, but you can get your ultimate result.
Yeah. And that's not something that we've gone to court for. It's just something that like you can let the sellers know. Is there earnest money has to be a part of that, I assume, as far as like having some kind of when you're the investor, you
Mhm.
have some kind of cash consideration on that initial contract to purchase. Is that correct?
In North Carolina, the purchase price is considered enough of consideration, and earnest money and due diligence, which maybe we get into this, maybe we don't. Due diligence fee is often considered. People think we're scamming people in North Carolina with that due diligence fee, but those are optional. It's not required to make the contract itself binding. The purchase prices, but earnest money or money that's been deposited goes a long way when you've got facts to support your case to say, okay, we clearly had a deal. There's money that's exchanged hands. I've delivered it. The sellers accepted it. It's it's good money. It actually cleared an account, just to go that extra step to show that it is binding. Now, some states may require earnest money to make it binding, but we don't.
Got it. That makes a lot of sense. All right, so obviously we do a lot of vacant land, everything like that. How does someone who's buying vacant land kind of protect themselves? Like we've had title insurance claims, things like that. But in terms of like general insurance, because we're sending people to the land, everything like that. And a lot of these questions we got directly from our community. So I'm excited to kind of talk about these, help people answer these questions, because so many people in this business like get tied up on little things and like, all right, I get it. So we're going to get right from the source here. What kind of insurance should someone get if they're trying to buy a piece of land? They buy it and they're flipping it 6 months later. Is there anything that they need?
Yeah. So I'm a lawyer. So remember, I tend to be on the more conservative, less risky side of things. So keep that in mind with my answers. I wouldn't have it completely uninsured. General liability, make it part of an umbrella policy, something, because if you've got people on the land and they get injured, you want a well of money to pull from to compensate them if you are in fact liable for that thing. You obviously don't need homeowners insurance. If you were going to build in a very short amount of time, then you might be looking at builder's risk. But in your scenario there, that wasn't probably the case. So kind of a general liability insurance, or, making sure it's part of your umbrella policy may be sufficient, based on if all you're going to do is hold it and then sell it, and you're not going to be doing any activities out there. But based on the types of activities you'll be doing there, you may want to talk to your insurance agent and have more things bolted on, just so that you don't have any risk. Nobody wants to spend money they shouldn't have to. So this is where I think an insurance agent that you can trust really well, and they're not trying to sell you stuff just to sell you stuff, is really important. Because that relationship goes a long way. They can be honest with you and say, that's overkill. This, based on what you're doing, is really important. And if you don't get it, here are the risks. So, I defer to insurance agent on that, but I'm not a big fan of it being wholly uninsured. Now, from the title insurance perspective, is it okay if we talk about that for a minute?
Sure. Yeah, I want to talk about
that. Not as much anymore, but used to get a lot of people that say, I don't want to pay for title insurance. I'm going to sell this right away. Owner's title insurance, if you're not getting a loan, is not required. And in fact, even if you are getting a loan, only lender's title insurance is required. So you can always opt out of owner's title insurance, but it's a bad idea, especially with vacant land, because of the rise in vacant land scams. So they're all over the country, but we see it in our area quite frequently. In fact, just yesterday, we caught a vacant land scam at the very beginning of the contract, where people are impersonating sellers of vacant land, because those people often don't live near the property. They live in another state. It's unencumbered. So they just try to sell it out from underneath them and pretend that, that they are the true owner. So title insurance covers backward looking forgeries. So if you come to own property in a way that is unsavory, but then you sell it, the title insurance that the buyer purchases is going to look all the way back in the title and cover defects up to that point. Hopefully by then you've figured out the scam and remedied that thing. But if it gets all the way to the next buyer and they've got title insurance, there's coverage there. Title insurers are getting more and more reluctant to pay out those claims, especially if there's negligence in determining the identity of the seller. But it's really important to have title insurance. But also, if you're uninsured, even for just a 6-month period of time, and that claim falls within that window that you own the property and you don't have title insurance, then it's on you monetarily to fix the problem when you sell. That defect doesn't go away when you sell. So you still have to solve it to provide clear title to a buyer. And you don't have anyone to call to help with that monetarily. It's at your own expense. So really not a big fan of opting out of title insurance. And I'm in a state where attorneys can't sell title insurance. So I get nothing from telling people title insurance is a good idea. So I always like to say that, because people will be like, well, yeah, she makes money off the policy. I do not. I think it's important. I really believe that you should have title insurance.
So is title insurance covering... Actually, let's back up. So let's say I'm buying a property from someone who's owned the property for 50 years, very clean. Like I have more experience from most people listening, looking at deeds, everything like that.
Right.
Not saying I would ever do this, but I look at like, all right, this person, it was clearly transferred from this person to this person. I am talking to this person, and they've owned this property for 50 years. There's still obviously a risk, I'm sure, with
Hmm.
fraud, everything like that. Is that a situation where potentially someone wouldn't want to have to pay for title insurance, or like that would be less risky in your mind?
It would perhaps be less risky, but your title encompasses so many things. You're talking about access, whether someone's trying to claim an easement and whether or not
Mm,
it really exists. Depending on your plans for the property, if there's an easement that cuts right through the middle of it, that might blow up your plans. So if someone's claiming that for the last 22 years they've been using that as a footpath to get to their deer stand for hunting,
mm.
that's going to cause a problem for you. You may not be able to subdivide if that was your intention. So title covers so much more than just the identity of the seller that I still am reluctant to tell someone not to get it.
Yeah. No, that makes a ton of sense. There's a easement access property a few years ago that we had, and it was 100 feet off the road, and the easement was written into the legal description, and
Hmm.
the end buyer ended up getting it. We were buying for like 40 and selling for like 79 or something like that. And the end buyer ended up like wanting a survey. I'm like, "Oh, that's fine. We're insured on the access." And then the end buyer gets a survey. They're like, this is a broken easement that was written on the legal description. The easement cut through like just outside of our corner of our property,
Ah,
and title insurance wouldn't pay it out. So that's what I wanted to get to there is like,
oh, yeah.
you spoke about it a little bit ago, like title insurance just like trying to be reluctant. I think all insurance, I don't think it's just title insurance. Like insurance companies
Right.
don't want to pay things out. They're looking for reasons why not to. How often is it difficult to do? I've never gone through with the title insurance claim. We ended up just selling that a lot cheaper without
Hmm.
access. But what does that insurance claim look like? How
Hmm.
often are those failed versus succeeding?
Yeah, I've been lucky in my career to not have a lot of experience with claims on title that I've been involved with, but I have helped clients who have been dealing with that issue of a property they might have purchased elsewhere or in a different part of the state, and they're dealing with the title insurance company on a title claim. And a lot of times, what it comes down to is what was investigated. So, I'm guessing maybe you didn't get a survey when you bought.
Did not.
Okay. So the what a title insurance company is going to do is they're going to have a standard exception for anything that could be discovered by a survey, right?
Mhm.
So they're going to say, well, if you had gotten a survey, you would have found out the same thing. And so we could have fixed it before you ever came to own the property. There's all kinds of reasons to get or not get a survey. So it's not right or wrong as to whether you get a survey, but that is a reason that a title company will choose not to pay your claim because matters that could be discovered by a survey are going to be an exception to the policy. So that's another reason why we will encourage people to get a survey. We don't require it, but to eliminate that exception from the policy and also give us a chance to catch those things. But I have seen title pay claims, especially when someone is trying to claim an easement that, in North Carolina, we call it a prescriptive easement. I think most states call it that,
Hmm.
where it's not written, but by many years of use, every state's got a different time period. But by meeting that certain years of use and the length of time and other criteria, that someone will try to say they've got a valid easement that completely messes up what you're trying to do. And I've seen title pay out on claims like that. And in some ways, it's getting rid of the easement or fighting to prove that the easement doesn't exist. Or in other cases, it's saying, all right, you are harmed by X amount because this easement does in fact exist and it wasn't discoverable. So we're going to pay you that amount to make you whole.
That makes sense. So, what other exceptions, like when someone just giving advice to someone who is not a legal person, like someone who's
Mhm.
watching this and they're buying land, like what should they be looking for on exceptions that, like,
Mhm.
okay, this can catch you off guard when you're going to sell the property literally a couple months later?
Right. Restrictions is the biggest one, I think. We have people that'll say, oh yeah, I looked at those restrictions, but they really didn't. Or maybe they just looked to see, that it was the proper subdivision. But when you got a set of restrictions that's got 13 amendments, I can see why people are like reluctant to read the whole thing. But their restrictions are there to restrict the use on the property. It means you can't do something with it. So if you buy a property subject to restrictions, a title company is not going to cover you if you find out later that, oh, darn, the thing I wanted to do actually was restricted against. So restrictions being the main one. It's less of a problem on vacant land, though it can be. It's more of a problem with like residential, something with a dwelling on it. And then easements of record, um, whether that's for utilities or for access for another party, shared wells, etc. So easements and restrictions of record, basically anything that you can find on the Register of Deeds in the affected time period, the title company is going to say you took title with all of that already existing. So if it could be discoverable and you just chose not to discover it, then, or you chose to ignore it and hope that it wasn't really an issue, then they're not going to pay out for that.
Yep. So with restrictions, what are you guys, or what is the title search finding? Because for us, like buying vacant land, like we want as little restrictions as possible. We're doing rural America where we're not like in the middle of Charlotte, North Carolina. We're outside there. We want mobile homes to be allowed. We want hunting to be allowed. We try to stay out of city limits for the most part. Like, are all restrictions going to be shown on those, or like where else should they be looking if it's not on the insurance policy?
Yeah, so I would not rely on the prior, if you get the prior title insurance policy, they may not list every book and page of the restrictions. So I would just, whatever attorney or whoever you're working with on the title search, I would ask them to provide you the list if you haven't found it before you went under contract. They're public records. So if you're adept at searching the Register of Deeds, you can find them before you ever make a deal. But yeah, I wouldn't rely on the title insurance policy to disclose because it's just a blanket saying, hey, any restrictions of record. But the going on the Register of Deeds and pulling all of those, because like you said, if you want to be able to allow mobile homes, a lot of restrictions don't allow those. And they also may say if you want to subdivide, they can't be smaller than 1.5 acre or whatever. And maybe you didn't want to have to subdivide that large. Or, you can't have certain, every dwelling that you put on there has to be of a certain size and certain materials. You don't want to be put into a box. So yeah, the restrictions, looking at them first is important.
So, and is that just deeded restrictions, HOA restrictions? We're not talking about like county restrictions being like, because a lot of times you can't find those on the Register of Deeds or anything like that. Yeah. Call the county up. I just want to be clear with everyone. If you're in city limits, like call the city, because it's not going to be on every deed. You cannot put a mobile home, but a lot of cities do not allow mobile homes within city limits. Just to be clear, right?
Right, exactly. And you may have, whether it's the city or the county, my area, the county is controlling the zoning. So you're looking at the countywide, and then you're also looking at even more restrictive things in your local city or town. So you're looking at a lot of different ordinances. And I love what you said about calling. So many people are afraid to just call. Like, just call. They have to tell you the answer. So go straight to the source. We'll get people that'll ask me, what do you think the county will say about this? I'm like, well, I can predict what the county will say all day long, but until the county says it, I could be wrong. Yep. So let's call the county together. So I love that you brought that up.
So we always go like with our due diligence once we get something under contract. The first thing I always do is like look in the area. Like if I'm in city limits and I'm trying to find out if mobile homes are allowed, let's look if there's any darn mobile homes in the area. Let's look if there's a lot of, like if I'm in areas with 40-acre parcels, like let's look if things are subdivided. And then I can call the county and be like, looks like things are being subdivided. What's your restrictions on subdividing? Opposed to everyone who's just like, I don't know, like you said, people are scared to make phone calls, and you want to go into those phone calls, I think, with some background as well. But that's really good information.
Ever wondered how land investing can be the fastest path to financial freedom? I break it all down in my new book, One Lot at a Time. I'll show you exactly how to find, buy, and flip land for huge profits without dealing with houses, tenants, or any crazy renovations. It's simple. This is the book that I wish I had when I first started. If you're ready to take control of your financial future, grab a copy now. One Lot at a Time by Daniel Apke. Find it at your local bookstore or on Amazon.com.
So a lot of people, I'm in Ohio. I've done deals in 42 of the states. And a lot of people always ask, like, what do I do in terms of entity structure, anything like that, when you're doing deals in so many states? I know states are different. Do people need a foreign entity in every state, or we can just talk about North Carolina as well?
Yeah.
But what does that look like when they're setting up their business? Like our LLCs out of Ohio, we're doing deals everywhere else. I let our accountant handle a lot of that stuff. But what should they do? What do you expect from someone doing deals in a lot of states?
Yeah, so it kind of depends on the state's definition of doing business. So, any state that you're doing business in, they're going to want you registered there because they're going to want to be able to get you for taxes one way or another. They want to know you exist so that whatever taxes they believe you owe, that you're going to have to pay and that they can collect, annual report fees, et cetera, from you. So if owning one property for a leisure purpose, maybe not be considered doing business. So you don't have to go to the expense of registering your entity. But if you're, coming in to own multiple properties to subdivide then sell, that's, it's really hard to argue that you're not doing business in the state.
Mm-hmm.
So I've seen plenty of entities come here and not be registered, but still be able to successfully do deals and not have any negative consequences from the legal side of things, but they may end up with tax problems. So I always think that's a two-person conversation, or two people to check with, is your accountant and your attorney whenever you're doing the deals, to figure out what exactly is doing business. Like, are you establishing a nexus that you're going to have tax consequences if you're not filing? But I've seen it done both ways, and it's kind of based on what are you doing with this deal, how many deals do you have going on, because maybe you can get away with not doing it, but it's very fact specific.
What about like when you're first getting started in the business? Like, okay, I'm just getting started. Like, I'll get an LLC in a couple months.
Mm-hmm.
What's your opinion on that standpoint where, like, okay, some people, like, you're just trying to flip land. Like, let's see if this works
Mm-hmm.
out the first couple months. I can always transfer things. I can still write this off. Like, these expenses are still business expenses, even though I don't have a LLC technically set up yet. What are your thoughts on that? Like, should everyone who's getting into a business like this, like, start an LLC right away?
I'm hesitant to say right away. I think it's if everything is in a perfect world and people have the time and the money and they're diligent, sure, get the protection immediately. But the world doesn't necessarily work like that. So I'm reluctant to say, you've made a huge mistake if you don't do it immediately, because there might be instances where you're fine. Now, when I don't think you're fine is when you have a lot of assets and you're dipping your toes into something because you have no liability shield and you're opening all of your assets up to, be, you're not judgment proof in any sense of the word. Mm-hmm. So if something goes wrong with this deal, you get sued, or any issue, and you get sued and there's a judgment against you, you've now exposed everything you've got to be seized to fill, the whatever obligation you have in the judgment. So perfect world, best case scenario, get your liability shield in place right away before you've acquired further assets, so that you can keep that asset protected. But there might be times, based on the circumstances in your life and what you're doing, that you might not get it done before you ever buy that first property, but it's not a good idea to go without it forever.
Yeah.
You do not want your assets exposed.
Yeah.
Nobody wants to get sued, but people can sue whether they're right or wrong about what they're suing for. And you really don't want to have everything you've got, exposed to be used to satisfy a judgment.
The reason I don't want to say hesitant with getting an LLC, but as far as like, so many people like look at it as a reason not to start their business right now. Like, I gotta get my LLC set up. You can send marketing in your name, and like, once you get some deals under contract, like you can get an LLC like over that stamp. Like, there's so many quiet periods in this business when you send out marketing, everything like that. Like, there's time to get set up with an LLC.
Right.
So many people are like, I cannot do anything in this business until an LLC.
I don't agree that you have to like wait until you get the thing from the Secretary of State. Yeah. That's and that's kind of when I'm talking about circumstances, life moves too quickly sometimes. Mm-hmm. If you've got a good deal in front of you, are you going to just let all these good deals pass by because you don't have the admin time to go file your LLC? You probably should not do that. Mm-hmm. Like, get going. The LLC can be added. But if you've got all the time in the world and you're not letting deals pass you by, sure, go ahead, set it up. But I think you make an excellent point that don't let that be the one reason why you're not getting started.
For sure. So marketing, obviously, like reaching out to sellers is a huge point of like, that's how we do business. Like, we're not finding deals on the market typically, like we reach out to sellers. some states have gotten really strict with some things. Obviously, texting seems like there's always, I don't
Yeah.
fully know everything. I've talked to texting companies who are like, yeah, if you do it this way, you're fine. If you do it this way, you're opening yourself up to liability or a lawsuit potentially. Is that changing a lot in North Carolina in terms of like mass outreach of, let's just say texting? Are you familiar with those laws or like what that looks like? What makes it legal versus what makes it illegal?
Yeah, I think a lot of it has to do with like the data sources and whether people opted in.
Hmm.
So, um, I don't deal in that world a ton. I'm vaguely familiar with, the different lawsuits, and I hear it more with like solar companies than I do with what you do. But, them kind of mass reaching out to people that never consented to be reached out to, or, didn't realize their data was being sold for that purpose. So I think if you're going to do it, then you got to convince yourself that whatever company you're working with or whatever way you're doing it is complying with the laws of the state that you're doing business in. Because wouldn't it be, I mean, what a bummer to be doing well and believe that you are doing everything correctly, only to find out that some company that you were using for texts is the reason why you can't continue.
Hmm.
So I I just encourage people to research pretty carefully whatever service provider they're using, that they're being compliant. And usually those companies will show you. I mean, if they're being compliant, they'll show you how,
Yeah.
and they'll show you whatever the rules are that they're following and how they follow them.
Yeah, and from what I've talked to them about, and I've talked to them, and we vet them pretty heavily in terms of these companies. And again, I'm not a lawyer, obviously, but they say, as far as like the mass texting, like if you are able to have a one-on-one conversation with them, it doesn't deem mass marketing. So what's banned and like what you need to opt into is mass marketing. And when you're doing one-on-one communication, it's not deemed mass marketing. Where if I can respond, so a lot of our people send 100 texts a day or something like that. If you send 100,000 texts in a day, it's like there's no way you can respond to every
Right.
response. That's marketing versus 100 reach outs a day. From, again, this is what the texting companies that I have talked to say, like, and obviously they have incentive for it to be like okay to do, but that's what they say from their perspective. It's like
Yeah.
what the definition of mass marketing is, and mass marketing is what needs to be opted in versus one-on-one conversations. There doesn't necessarily need to be opted in, but there are do not call lists,
Yeah.
obviously.
Yeah, that makes perfect sense, because if you're thinking about 100 outreaches a day, I mean, that's just cold calling. That's just sales, right?
Hmm.
That's every industry does that every day. And that's just a good sales technique. And of course, the people that you're reaching out to, if it's a one-on-one conversation, then they can just not answer if they don't
Yep.
want to answer, or they block you or whatever it may be.
So you said you've done quite a bit in like, have you done a lot in like zoning changes, or like what is your kind of background in zoning? What does that look like? Because I'm curious, because me too, I haven't done a lot of like gone through zoning changes. It seems I don't know, it's intimidating, I think, for a lot of people. But you can make just a zoning change, going through entitlement, like you can make
Yeah.
a lot of money just by doing that. What does
Yes.
that look like? What's your experience with that? Like, what's the process of changing zoning of a certain parcel?
Yeah, so one of my very first cases, no, it was my very first case, was a major rezoning in the town where I live in Mooresville. Costco wanted to come to town, and I don't know if you know a lot about Costco's history, but they've never closed a store. They bring a lot of jobs, they pay well, pretty good business to come to your town if they want to come. And I represented a family who wanted to sell to Costco, but as part of the rezoning process, they were denied because local people didn't want the Costco, the not in my backyard thing.
Yeah.
So they all spoke against the development, said that it was going to cause too much traffic, etc. So we came in and had to show that, in fact, it would not cause too much traffic, that all the traffic studies said the opposite, because of the development, or the developer was going to advance some road improvements that were long delayed by the state. And all of the different things that they were going to do was actually going to help traffic in that area. But more importantly, we discovered that when the town denied the rezoning, they didn't do so in accordance with their own ordinance.
Oh.
So, of all things, a 2-sentence "we deny" was missing about 6 words. So now Costco is in Mooresville. But I give all of that background to say there's so many layers of a rezoning that have to be observed. So there's potentially traffic studies needed to allow for the rezoning. Not every project will require that. There's probably stormwater plans. You're going to maybe have to have a retention pond, or they're going to figure out how much impervious cover you intend to have, to see what exactly you need to do as far as like planting trees, common open space, whatever it may be. So the rezoning process is very layered, but it's not always scary. There's other projects in town that we've seen where, the all it took to get rezoned was acquiring about another half acre of land because they didn't have quite enough pervious area. So that's a pretty easy problem to solve, is going to your neighbor and saying you're going to pay them a pretty good chunk of money for a half acre of land so that you can go then make 6 million selling to a big developer, right? I would say people don't be afraid of the rezoning process. Just, this is a great time to call up your city or your county and ask them, I'm thinking about doing this. What does it take? And then your planning director or whoever is working in the planning department will sit down with you in the town hall and tell you, this is what we need you to do. And you decide from there if you want to move forward or not.
So is that like the first, let's say someone wants to do, you have minor and major subdivisions in a lot of counties. Like, okay, minor is very easy, survey. A lot of areas we do it in, like, it's very easy. Like, get a survey, you're fine. Stay under these requirements, you're fine. It's not a major subdivision. Let's say someone wants to do their first quote unquote major, not like 100 lots or anything like that, but 10 acres into 10 1-acre lots into that. Like, is that just the first thing you suggest is like, okay, are you reading through all the guidelines, everything like that? Or are you just making a phone call, like, let's have a conversation and see what we can do about this?
Yeah, I would usually start with, well, you already made the first suggestion, which is look around and see what's already existing. If you are the first to do it, then I would start with after you've determined nobody else has done the thing that I want to do, I would make the call. Because they could pretty easily tell you, oh, you're running into the issue with we don't have sewer available. And if you're not wanting to undertake dealing with septic and septic easements and having offsite septic lots or whatever that may be, if that's not what you want to do in your first subdivision, maybe that's not the right parcel for you. But that first conversation really gets you started in what you need to do and figuring out how you need to lay out the roads, that's going to be invaluable. So that's where I would start.
Yeah, that's a good point. Is it harder a lot of times to get zoning changes in like small cities? Because it seems like there's more resistance maybe to change. Is that a thing? Because it seems like Costco thing, like, yeah, we're just saying no. Like, it's not like we don't care what it's like. We're just saying no. Is it a lot of times harder in smaller cities?
Oh, yeah. So much of the not in my backyard. And that's the right of the people to say the thing that they want and to get their representatives to vote for the will of the people. So I don't begrudge them their opinions, and that's the way the system is set up so that the people will have a voice. But sometimes the opinions are not based in fact. So, it can be more difficult, especially in a smaller town, because you get the hive mind and you get like the vocal person that convinces all the neighborhoods around them that this is going to be the worst thing that ever happened. But funny enough, when I go to Costco, I often run into people that I had to depose for that case. So they ended up liking Costco in the long run.
That's crazy. Yeah, we have someone who is they're subdividing, I think 48 acres into and they're building 90 tiny homes or something like that. And like, I had a conversation with them. They're like, we just had to get a lot of people on our side, and like people going to the town hall meetings and just like advocating for it. It's to help it's to add low income households. It's to bring some veterans into that community. So it's going to help a lot of people. And like, they just got a lot of support. And the hardest thing is getting the people who own land in that area, because it's changing their backyards. Literally, they own 5 acres and now there's going to be 100 houses right behind them. So definitely changes. And I think getting people on your side is a huge aspect where they can be a voice for you.
Yeah, it can sway the whole outcome. So even just from the beginning of the meeting to the end, the show of public support or the opposite can change a commissioner's mind. They might have come in saying all the facts say we should deny, and then everybody loves the project, and they're like, okay, well, my constituents love it. This is not going to be good for me at re-election time if I'm always saying no to them.
Let's talk about deeds real fast before we hop off here. Because a lot of people, like, you have general warranty deeds, all these things. The first thing, like, if a husband and wife is on a deed and one of them passes away, or let's say it's a husband and wife on a deed and both of them pass away, and you're talking to the child, like what does all of this look like? Talk to like what should they be looking for if they have a potential deal and like, okay, you're not on this deed, I'm talking to someone
Right.
else, and or like, okay, who's this other person on this deed? Do they should need to sign as well? Like what should the first thing they be looking at?
Yeah, so depending on the scenario, it's different. So the first one where you've got a husband and wife and maybe one of them has passed away. In our state, we have something called tenants by the entirety. So, if your spouse passes away, you're the sole owner. You don't have to do anything else. But in any, basically any other type of ownership, you're dealing with an estate if somebody passes away. So your first thing you're looking at is, did they have a will or not? Is that will filed and probated in the county where the property is located? Because that's how you'll find out who the heirs are. And the heirs are the ones that are going to have to sign everything. And what I often see is an executor will have been advised mistakenly that they're the only person that has to sign. And so you'll be negotiating with the executor and they don't have the full authority to bind. And you'll end up finding out that one of the heirs wasn't on board with the project or with actually going through with the sale. And then you got a deal that falls apart. So not relying on solely what you're being told and going to the public records and finding out who are the exact heirs. And we also, North Carolina has a weird thing, I don't think it's common in most states, something called a marital interest. So even if you buy a property by yourself, if you're married and you don't have some other agreement that's been recorded to sever the marital interest, your spouse has to sign with you. And that's true even if you inherit property. So you might be talking to a group of brothers that want to sell the property, and just one of them has a really mean wife who doesn't want to sell the property. If she won't sign, your deal is done.
Wow.
So those are things that, starting with the estate file, finding out the marital status of the people you're talking to, just so that everybody who's going to have to sign the deed is signing the contract, invaluable.
Yep. A lot of states have right. Is it called right of survivorship? As far as you said, it's called when two people entirety. Is that what you said? Is that
Yes.
correct?
So we have rights of survivorship as well that you can use even if you're not married. But
Got
if
it.
you're married in North Carolina,
automatic.
you can also use the entireties.
What about like, do you guys have like affidavits of heirship with no wills? Like, what does that look like without a will? Because that's what we've done in a lot of states. Because way less people have wills than I thought.
Right.
And like, okay, it's the whatever. Both parents or one person's dead, and it's the only owner on the property. And affidavits of heirship are essentially no will, and these children can sell, or whoever it is in that state has the rights to sell without going through probate, everything like that. Is that something you guys have in North Carolina?
We do. And we often don't have to get to the affidavit portion because our laws of intestacy, the fancy word for dying without a will, are pretty clear about who takes in what share. Where we have to bring in the affidavits is when, the children have passed and then their children have passed and then their children, this is like been in the family for 100 years and nobody had a will and nobody filed an estate, right? So we do have those affidavits. They've got some requirements of people that have known the family for a long time and that can attest to where they've lived, who were the kids, etc. But we do have that process as well. We just hope that we don't have to use it.
Got it. That makes sense. And going over to the deed portion, a lot of times, like our students or something, like they freak out because the most recent deed's a quitclaim deed or whatever it is. It's not a general warranty deed. And I always tell them, just get title insurance, do a title search, and the title company will figure it out for you. Is that the right thing to tell them? Because a quitclaim deed can just be family to family a lot of times. It's just like, okay, we're not going to do a title search on it. Is that essentially what it means? Is that correct?
Well, that's one of the main use cases for a quitclaim deed, but a quitclaim deed is no warranties implied, right? They're saying you get whatever I get, if that's anything at all. So someone could sign a quitclaim deed to you for a property that they've never owned, but they never promised you that they owned it.
Yeah.
So, a quitclaim deed does have risks, but it's more often used in that family to family scenario or a divorce scenario where one spouse needs to come off of the deed, but they're like, listen, you've lived here too. I'm not promising, don't come after me if something goes wrong because you bought it too, right? So a quitclaim deed alone is not the thing that scares me. It's once the title search reveals, oh, that person who signed the deed didn't actually own the property. That's the
Yeah.
problem, right? So a quitclaim deed, I wouldn't say it needs to scare you off. You just need to do your research. You need to make sure that the title search doesn't reveal any defects and that you get title insurance, just like you said.
Yeah. And then you sometimes have people try to sell things on quitclaim deeds and they're one of four people who own it or something like
Right.
that. And then that's obviously breaks the chain of title. Interesting stuff. Anything else that people should be thinking about as they're doing this business? Obviously, there's so much we could get into. But as
Right.
they're buying, flipping, selling real estate, vacant land, anything else they should be thinking about as they're doing this business?
The number one thing I would say is just because you have one bad deal or difficult deal, don't let it stop you. Because you learn so much from the hard deals, and then you'll spot it next time and you know how to deal with it, and it won't be so hard anymore. So I think people, if they get a really rough one early on in their career, they're like, yeah, this is not for me. But maybe it is. And you just had one, you had a stroke of bad luck, but because of everything that you learned, it's going to make you a better investor and going to make you better at real estate. So I know that's not necessarily legal based, but I just encourage people not to quit too early.
No, that's amazing, and we try to push people because it's the first 6 months of doing this business is not a simple thing. Like there's a lot
Right.
of learning, obviously. But Tiffany, I appreciate you coming on. Where can people find you? If they're
Thank you.
doing deals in North Carolina, are you strictly in that Charlotte area? Where are you doing? Where are you guys representing buyers,
Yeah.
sellers, everything like that?
Everything around Lake Norman. So all the
Okay.
counties that touch Lake Norman, we can do anything in North Carolina, though sometimes it's not economical for a buyer to use us to do that based on their location. But the firm is Thomas and Webber. We're in Mooresville, Huntersville, and Denver, North Carolina, just all around that lake stuff. So definitely, if you've got Lake Norman stuff, we know everything that's going on with that.
Awesome. Well, we'll put your information in the description below. If you guys are watching on YouTube, hit the subscribe button below. Tiffany, we appreciate it so much. It's an amazing conversation. We'll see you guys next time.
Thank you.